So the first topic that we're going to be addressing is the Michigan sick leave and minimum wage law that we've been waiting for so long. The Supreme Court has now issued its decision. The panel that will be addressing this topic is Tony Delamonte, Cliff Hammond, and Mike Cluck. And we will begin with a short summary of this law or these changes from Tony. Tony?
Perfect. Thanks, Mike, and thank you all for attending. As I'm sure you've read in the news, big changes are happening to Michigan's sick leave and minimum wage laws. And the date that I want everyone to write down, circle, star, is February 21st, 2025. That's the date that the Earned Sick Time Act and the Improved Workforce Opportunity Wage Act will be replacing Michigan's current sick leave and minimum wage laws. And just real quick on how we got here, on July 31st, just a few months ago, the Michigan Supreme Court held that the manner in which our legislature enacted the current versions of Michigan's minimum wage and sick leave laws was unconstitutional. So the original versions of these laws from 2018 will be going into effect in February. And if you want any additional information on that, we're happy to provide, but we want to focus on what you need to know about come February. So briefly on the minimum wage changes, Michigan's minimum wage will be increasing on February 21st from $10.33 to somewhere between $12.20 and $12.50. The reason it's a range is it's based on a present value calculation, and we're waiting on the state to give us some clarification on what exact dollar figure that will be. But what you need to know is that Michigan's minimum wage is increasing, and it will be increasing on a yearly basis. And the other big deal is that the tip credit is going to be completely phased out by 2029, which is obviously a big deal for the restaurant industry. And the percentage that the tip credit must be of minimum wage is going to be increasing on a yearly basis as well. So those are the big things you need to know as for minimum wage. Turning to sick leave, and I think everyone on this panel can agree that we've gotten lots of questions over the last couple months on this statute, but the Earned Sick Time Act, again, is going to be going into effect on February 21st, 2025. And this is a big deal because now all Michigan employers that have at least one employee will be required to provide paid sick leave to their employees. This is a big change from the Paid Medical Leave Act, which is the current sick leave law, because employers with less than 50 employees didn't need to provide paid sick leave or weren't statutorily required. And the state came out recently and estimated that 1.4 million more Michigan workers will be covered under the statute and receive paid sick leave than previously. So how much time do you have to give? Well, under the Earned Sick Time Act, employees will accrue sick time at a rate of 1 hour for every 30 hours worked. Companies will be required to allow employees to use up to 72 hours per year if you have over 10 employees. If you have less than 10 employees, then you must allow employees to use at least 40 hours of paid sick time and 32 hours of unpaid sick time. So, if you got more than 10 employees, you need to allow employees to use up to 72 hours per year. And if you're on an 8-hour workday, that's 9 sick leave days per year. And some other important, changes that you need to be aware of is that employers will now be required to have their employees carry over unused sick time on a year-to-year basis. So if you've got someone who has 72 hours of paid sick leave, they only use 10 of that, then you must carry over 62 hours of paid sick leave per year. But the good news is you don't have to pay out that time if an employee resigns or is terminated, so long as that's compliant with your policy as well. And the other point I want to make is that this applies to all employees, part-time, temporary, seasonal. There's no exceptions. There were a few exceptions under the Paid Medical Leave Act. Those are gone. So it applies to all employees. It does not apply to true independent contractors, which I believe we'll probably get into in the Q&A. But the state has come out recently and said that if you're a true independent contractor, then you don't need to provide paid sick leave to that employee or to that contractor. The other point I want to make is that this is a really pro-employee statute, and there's now new liability that employers need to be worried about. Employees have the right to sue for violation of the statute, which you didn't have under the Paid Medical Leave Act. And there's some really employee-friendly retaliation provisions that present new liability as well. So, for example, there's a record-keeping provision that says that you need to keep track of the hours worked and how much paid sick leave is used for employees for at least 3 years. Now, this matters because if you get sued under the statute, there's actually a presumption that if you don't have your records in order, there's a presumption that you have violated the act. And then on the same note, if you take adverse employment action against an employee within 90 days of them, complaining about your sick leave policy or, participating in an investigation of the sick leave policy, or really, talking about your sick leave policy, there's a presumption that you have retaliated against that employee. And damages can include, back pay, reinstatement of the employee. And the biggies are liquidated damages and attorney's fees now. So, this is a big deal. It presents a new area of, potential liability for employers if you don't comply. So we want to make sure that, everyone's compliant, you're doing things the right way. And we can talk about some best practices here. But want to toss it over to Mike to get into some questions.
Sure, thank you. And there are some questions in the chat box. One of them goes to handouts for the presentation, and that's what Kim said at the beginning. We're not going to be using PowerPoint because we have a panel, and we're going to have people addressing the questions as we go. So there's not going to be a PowerPoint presentation in the background here, but there is going to be materials available at the end. So what we're going to be doing today, though, is having the entire panel up and addressing the issues. So the questions, one of the questions came in actually before today. And so I'll start with that one. It concerns the notice on the ESTA, and particularly the fourth bullet point. And it correlates to Section 5 of the Act, which is the section that says if you provide leave sufficient to meet the requirements of the Act, you're deemed to be in compliance. And I think the question, and Cliff, I'll throw this out to you, do floating holidays count as paid time off under the ESTA?
We don't have that particular statement in here in this law that says this is exactly what it'll apply to. But what it does say is that if you have an existing policy and program for time off, you can utilize that to comply with this law and its requirements. So long as you're able to have as many hours that you have under the Act in your policy, and you can use it for all the same reasons, then you can generally do that. Now, the way we look at the statute and the way it's envisioned is if you have a sick time policy already in place, then that can do it. If you have a PTO policy, that can also meet it. Where you have a floating holiday, though, that doesn't necessarily seem to meet the criteria of the type of leave that you're looking for, because what you would end up doing is taking something that wasn't for time off for sickness or illness or for vacation and putting in here. Without clarity from legislature, I would generally say that's probably not going to comply in and of itself. Obviously, it's not enough anyway. So your holidays are not something that's included in the statute, but your sick and your vacation time policies are expressly the ones they say you can use. So what you want to do is you want to focus on, does my policy currently allow me to have employees get 1 hour for every 30 hours worked? Can they use it for all the time that's necessary? And do I have it roll over? The problem with a holiday is you probably don't let employees roll over unused floating holidays. So there's a little bit of a problem with the way the mechanics would work with that holiday and how this does it. Because one of the things that this is very interesting, in our current rules that we have, if you give somebody a block of time of 40 hours or more at the beginning of a year, you don't have to let people roll over the sick time. This statute is fundamentally different. What it says is a person earns time, they use the time, and then if they don't use it all, they get to carry all of it over, not some of it. There can be no cap. You have to let them carry it over. Now, depending on if you're a large or small employer, more or less than 10 employees, there are certain rules on how much is paid and not paid. You can limit the use, though, to 72 hours, whether you're small or large. And there's a component of, if you're a small employer, you only have to pay for 40 in the year, and then the remainder can be unpaid leave. But if you're an employer that's a larger employer, then you're going to have to let the person receive up to 72 hours. So even if their bank has 1,000 hours, you can say you're limited to using 72. So that's why I would say the floating holiday doesn't really match what we're trying to do here. What we're trying to get here is an opportunity to have days that can be banked, that can be used, and then with the only caveat being a limitation, because unless you're a federal employee, you are covered. So that's part of this. It's a very big blanket that they're covering everybody with this. I mean, the whole goal was to get everybody you possibly could. And the only limitation really is whether you have to give 40 or 72 hours of paid time per year.
Okay, thanks, Cliff. And the other thing I think you want to remember with the Section 5 language about deeming to be in compliance, that not only includes the amount of time that is provided, it also requires that the time be used under the same conditions, which includes hourly increments. So if you're talking about paid holiday, the increments could be as little as 6 minutes, depending on how your payroll is set up for purposes of the ESTA. So I'm not sure you want to allow floating holidays to be taken in 6-minute increments throughout the year. I don't think that's the purpose of a floating holiday. So I think you got to think about how you're going to allow the use as well. Okay, the next question I'm going to toss out there, and Mike Luck, maybe I'll toss this into your little square here. And it says, what about union workers? Does the ESTA apply to union workers?
Well, obviously, collective bargaining agreements often have provisions already in them on the amount of sick leave accumulation. To the extent that those now equate to or even exceed the statutory requirements in ESTA, you're pretty well covered. What I'm facing right now, of course, if I'm at the collective bargaining table with a labor organization, and going back to Tony's date of February in 2025, in my opinion, if we reach an agreement for multiple years forward, okay, ahead of February 2025, I believe the statute as it's going to be applied will allow you to simply carry forward those negotiated benefits until it expires. If there's a disagreement on that, it'd be nice to have the panel chime in. But that's one of the things that I've been looking at, is trying to get CBAs in place, if I can, to help obviate this impact right now in public sector employers that have CBAs.
Thank you. The next question deals with the minimum accrual requirement. But the question specifically here is that if we provide sick leave or PTO of 80 hours per year, so in excess of 72, we have PTO 80 per year. Does the ESTA apply to us? What do we need to worry about? Tony, I'll throw that back to you.
Yeah, so like Cliff mentioned, you're permitted to have a combined PTO sick bank so long as your PTO policy allows you to use that time for the same reasons and under the same conditions as permitted under the ESTA. So, you can use sick time for sickness of, a child, yourself, a parent, for meetings at your parents' or meetings at your kid's school related to a health or a disability. So long as your PTO bank allows you to use it for the same reasons, then that's permitted. But the problem is, which we've talked about, is that you need to allow them to carry over any unused but accrued time. And if you've got a combined policy, it gets a little wonky. And I think, we panelists have talked about this ad nauseum, and frankly, I think we believe it's a lot easier to have a separate sick bank, because if you have a combined bank, we think you're probably in a position where you need to carry over all of that time unless you're, keeping track of which of those hours relates specifically to accrued sick time under the statute. So, the answer to the question is yes, you're allowed to have the combined policy, but the statute makes it a little more complicated, unfortunately.
Okay, and that answers another question that the PTO, it expands it a little bit for vacation, sick, or personal time. And the ESTA and the guidance that we have so far from wage and hour, that is definitely permitted. But as Tony just said, you got to be a little careful on how that impacts usage and rollover. The next question asks, does this apply to POCFF, which I assume is intended to mean paid on-call firefighters? If not, let me know, but I'm going to assume that's the case. So the question is that, does the ESTA apply to paid on-call firefighters? Cliff, what do you think?
Well, Mike and I have listened in on the Department of Labor to Michigan State, and they did a presentation right after this was done to try to say, hey, look, here's what we're looking at statute, because everybody gets these green statutes. They're new, right? They haven't been interpreted by a court yet. So you look to the agency that's in charge of, doing Department of Labor to clarify, because the definition of employee under the statute's a little odd. It says it means an individual engaged in service to an employer in the business of the employer. Now, that's a pretty broad definition. So you would think, okay, not just some voluntary firefighter who gets paid on call. You potentially could read that to say it's a board member on some board that comes in and gets a stipend. Now, what the Department of Labor has said in their online webinar, which you can access right now by going onto the materials, is no, that they're not looking at like board members. Now, they didn't describe the firefighter issue, but if you're paying somebody on an hourly basis on call to do work, and that's what you do, which is firefight, right? You're a firefighter within the department. There's a strong argument that says, yeah, that person should be covered. So the question here really isn't whether or not there are exceptions. The only exception expressly put into this statute is if you're a federal employee. So I would conservatively tell you that a person who is getting paid on call, they're literally getting paid. If that person at the end of the year is getting a W-2, there's a pretty good chance that person is going to be covered. And I would recommend that you do cover that person right now until we have a court ruling or some guidance from the Department of Labor to say, no, that wasn't our intention with the statute, because nobody actually passed the statute with the intention of getting it done. It was passed with the intention of getting it done and then change it quickly. So we don't have as much legislative history. But if you don't cover that person, you do have possible liability. And as Tony said, there's some big liability here. If you discipline somebody, you don't have the right record keeping, there are things in here that could hurt you if you don't do that. Now, again, I don't know whether or not somebody is actually going to file a claim because they didn't get their, I'm on call for 20 hours a year and I didn't get my my accrual so I can get a couple hours off here or there. I don't know how much liability you're going to have, but you still have some, and I wouldn't just play this game of saying, we're fine. And again, I would say this, anybody who says, well, what about me? What about me? I just read you the definition of employee. It's very, very narrow to get out of it. So you're probably going to be covered. If you have a question, we can really delve into it. But right now, everybody's covered, period. You have to let people carry the time over, period. You can't put a cap on it, period. You can limit the use per year, and you've got to notify employees as soon as this thing goes into effect in February. Here's our year for the purpose of usage. fiscal year, calendar year, anniversary year, and then you got to stick with it because that's what they ask you to do, and that's what you're required to do. And then you got to put a posting up, and you got to let people have it. And right now in our policies, Mike, I'm sorry to get outside the question, but I want to make sure that I cover because this is important too. When you talk about who's in and who's out, once you have a person in, there's some pretty strict rules on what you can do. You can't ask a bunch of questions of people. If a person says, hey, I was sick on Friday, under this rule, you're not allowed to ask them for documentation. You can't go out there and ask them for documentation for one absence. And basically, you can say, I need off for a covered absence. And if they've got that time, you have to pay them for that time. There are some other things you can do that we can probably get into, but that's important. But the other thing you got to remember is a lot of policies say you need to give us at least 7 days advance notice if you know you're going to need a surgery or you're going to need to be out. In the statute, it says 7 days. You can ask somebody to give you up to 7 days advance notice. It doesn't say you have to give as much notice as you possibly have. When there are some quirks to this that we have to go through, it's a very tight rules, specific law. That's why I don't want to play games on who's in and who's out. I would much rather advise people to not try to play games to get people out of it because of the penalties that are involved with liquidated damages, reinstatement, all the damages if you fire somebody for not counting the time. It's a really risky endeavor right now to try to play those type of tight games on this law.
Okay, thank you. And Tony, I'm going to throw this one to you. We've touched on this, but the question is an employee limited to using 72 hours in a year, even though they have carried over hours from a prior year and have accumulated more than 72 hours? And I will expand on that question to say limited. Would that mean can they use more if the employer agrees, or must they be limited? And does it matter if it's combined PTO bank?
So the employer can allow the employee to use more than 72 hours, but you can't allow them to use less. You're required by statute to allow the employees, so long as you have more than 10 or more employees, you have to allow them to use up to 72 hours per year. That applies with a combined bank as well. Again, so long as you're allowing employees to use it under the same conditions that we've talked about previously. So there is a cap on usage. It's 72 hours. There is no cap on accrual, however. So if you've got, it would be an hourly employee who, is working a ton. He's working a ton of overtime. Hypothetically, they could accrue more than 72 hours per year. There's no cap on accrual. There's only the cap on usage. And the other point I want to make is if you have a salary employee, the statute says there's a presumption that that employee is working, a 40-hour work week. So, you can use the 40 hours as the basis of the calculation there. But yeah, no, so it's 72 hours. And the other point I want to make, it would not be a good idea to necessarily take any adverse action to get yourself under that 10 employee limit. And here's why: because the statute is written in such a way that, let's say you're at 11 employees and, you were thinking about potentially terminating an employee before this statute goes into effect in February. The statute reads that to determine if you're a large employer or a small employer, they look at how many employees you've had for 20 or more weeks in the current year or the previous year. And whatever that is, that's you're either a large employer or a small employer for the current year and the next year. So the statute really, is trying to eliminate some gamesmanship there on, increasing or decreasing how many employees you have. So it's a pretty large time frame that you're looking at to determine if you have 10 or more employees. But yeah, again, usage cap is 72 hours if you've got 10 or more employees.
Okay, excellent. Now, there's some questions in here on the effective date, and they're in a few different ways. Let me just hit this one. First, has the new law, which I assume means the ESTA, taken effect where employees can sue for violation of the policy, or is there a start date in the Supreme Court? So the Supreme Court has ruled the effective date is February 21st, but can employees, or when can employees sue? And then there's a second related question, I think, or maybe not related, but it's when can employees use sick time if they're still in the 90-day training period? Does that start February 21st? Of next year, or when does that 90-day training period start? So Cliff, what are your thoughts on those effective date questions?
Yeah, and the good news is we've got some time. I think that's a great question because it tells everybody, all right, what are we doing now? What's our liability? What's our runway look like? And you've got time to get yourself ready before the 21st. No one can come back and sue you for things that you did before the law actually went into effect, right? So the law doesn't go into effect until February. So the good news is you don't have to do what the law says until then. So you don't have liability. The liability will start once we get into the law. So you have to have your records in order. You have to make sure we're accruing. But once we get into that process, this is a little bit of the, anytime you have a new law, you're going to have a honeymoon period where everybody's trying to figure out how to do it. This is like the FMLA or, the ADA, any type of law that is a small business you grow into being covered by it, or the law is just passed. So once an employee, let's just say you have a new hire, the new hire starts to accrue their time right away. They get to accrue the time, but you can't have 90 days before they can actually start using it. But if you have a current employee, my interpretation, and again, we haven't seen this being vetted by the court, would be if the employee's already worked for you for more than 90 days, and that person's able to use whatever time in the bank you're using for them right away in February 21, starting then. So there is no exception that I see in the statute, and the panel can obviously weigh in, and I'm sure there may be some courts out there that are going to look at this if there is a claim that's made, but existing employees should already have time ready to go in your bank unless they've used it already this year. So let's say you have a bank of time that's compliant with everything, or that you make compliant as of February 21st, but the person's burned through all that time and your year goes through December 31st. So if they don't have any time available and they've used all the applicable time they could have used, then you're not in violation because they've used it all. On the other hand, if you just say, well, listen, you're going to start accruing right away as of February 21, and our date for the year is going to start on February 21, then a current employee can use and accrue right away, but they don't get to use all the old time. You can change your bank you can zero out your old bank and say, we're going to start over new, according to a lot of different ways that you can handle this, but it's going to be a little bit of a rocky transition. That's why they did bump this out to February 21st. It seems like it's a long time away, but it's really not, because we've got to coordinate how we're going to transition from the old policy. Are we just going to update it? Are we going to create it from scratch? Or are we going to renew it so that it complies? So it's a little bit more complex than it seems. And of course, as usual with the courts, they're like, well, this is the law, figure it out. And then we'll come back and bang you on the head if you didn't do it exactly right when we didn't explain it. So that does happen from time to time, but I think we could work through it to get your policy appropriately adjusted to be able to make sure you don't leave anybody behind.
Okay, thank you. And there's a couple of questions, actually a few, I think, that I can bundle them. They deal with the rollover issue and the requirements or limits on that. And there's a couple of questions. If they roll over in 1 year, but then they still don't use it, can they continue to roll over, or how many years in a row can they continue to roll over? And then the related question to that is, at some point they leave, does that have to be paid out? They can't roll it over once they're gone, so what happens to it? Tony, your thoughts?
Yeah, so you can roll over every year. Hypothetically, if you've got a tenured employee who's been working for a while, and they don't use a lot of sick leave, they could build up that sick bank, to be pretty large. The good news again is that you're only allowed to, or you only have to permit them to use up to 72 hours per year. Again, if you're a large employer, and I think I saw one question in here about, can you explain the 10 or more employees? The 10 or more employees relates only to the usage cap. So if you've got 10 or more employees, then you have to allow employees to use up to 72 hours a year, even if they've got this huge bank that they've accrued over 20 years. If you have less than 10 employees, it's 40 hours of paid leave and 32 hours of unpaid leave. So that's, that's a little explanation there. And then as for paying it out, you don't have to pay it out if you terminate them, if they resign, leave, don't need to pay it out, which is good. I've seen a couple questions in here on, can we pay it out? Instead of letting employees carry it over. I'll defer to the panel. I think the answer is no. The way that the statute's written, it says that you must permit employees to carry over that time on a year-to-year basis. Now, again, like Cliff mentioned, this is really new. We don't know what a court would say if you paid out that time rather than carrying it over. But our best interpretation, or at least mine, is that you got to allow them to carry it over.
Yeah, and there's a related question, and this deals with PTO. And Tony, I think we've actually talked about this a little bit, is there's two different types of payout, I think. One is payout under PTO, and one is payout under ESTA. And the ESTA is clear, you don't have to pay out. But if you don't have separate banks, you have a combined PTO bank that you use to be deemed in compliance with the ESTA. And then there is time in that bank and the employee leaves, do you have to pay it out? And I think the answer to that question is it depends on how your policy is written, because we can look at the ESTA and say there's no requirement for payout when you leave. But the Wages and Fringe Benefits Act says that fringe benefits, which is leave time, is paid out in accordance with the written policy. So if you have a PTO policy that says when you leave, you will get paid for unused PTO time, then you may not have a violation of the ESTA. You may have a violation of the Wages and Fringe Benefits Act. So you have to look at your policies as well.